My name is Phil Sechler. It's great to be with you all here today. I'm Senior Counsel at Alliance Defending Freedom, and I'm in the Alliance Defending Freedom's Center for Academic Freedom. So for those of you who don't know, ADF is a nonprofit legal organization that advocates for the rights of people to freely live out their faith in courts throughout the United States. And the Center for Academic Freedom is the group within ADF that focuses on protecting the First Amendment on college campuses and in K-12 schools. So my presentation tonight will be in three parts. First, I'm going to provide a general overview of the free speech and free exercise rights held by K-12 teachers in the public schools. So on this, two caveats. First, of course, this discussion does not apply to teachers in private schools because the First Amendment doesn't protect those teachers. Second, this discussion does not consider other protections that teachers might have, like federal or state employment statutes or union contracts. In any dispute with a school, those things would need to be considered, but we're not going to address them here. Second, I will discuss the application of these rights in one specific area, and that's the area of sex and gender. And the reason I'm doing that is because that's really the issue of our day. It's becoming more of a challenge. We're getting calls from teachers every day in this area, and there's not enough time to address all of the issues that you face, including critical race theory and other things. So this will be a good focus for the application of the rights we're going to discuss. And then third, I'd like to brief you on some of the cases ADF is currently handling in the K-12 context. So, without further ado, talking about First Amendment rights held by K-12 teachers, we're going to cover three things. First, teachers' free speech rights. Second, teachers' free exercise rights. And third, unconstitutionally vague policies. And let me say before we dive in, there is no constitutional right to academic freedom. The term is often used to describe the freedom of teachers to pursue academic goals, but as a constitutional matter, the rights of teachers are rooted in the First Amendment, and that protects teachers' freedom of speech, not academic freedom. Second, keep in mind that schools have their own rights. They have the right to hire teachers, to set academic standards, to select the curriculum. So the rights of teachers have to be balanced against the right of schools to determine their own goals. And third, in this balancing of interests, public college and university professors have the greatest First Amendment freedoms, as those institutions are considered institutions where knowledge is discovered rather than simply transmitted. But the First Amendment does protect K-12 teachers' rights to free speech, both outside the classroom and in the schoolhouse. And the Supreme Court recognized that in the Tinker case back in 1969, saying, quote, "First Amendment rights are available to teachers and students. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. This has been the unmistakable holding of this court for almost 50 years. And this is still good law." So let's turn to teachers' free speech rights. The Supreme Court has established a framework for determining the rights of public employees generally. And that framework has three parts. Generally speaking, a public employee has the right to speak when speaking not pursuant to official duties, on a matter of public concern, and when the employee has a greater interest in speaking than the employer does in restricting that speech. And because public teachers are public employees, they're governed by this test. So the first issue, not pursuant to official duties, really concerns who is speaking. Because when the government speaks, it has the right to make its own choices about what it says. So when a public employee speaks pursuant to official duties, he or she is not speaking as a citizen, but simply as an arm of the state. And the First Amendment does not protect that teacher from discipline for speaking contrary to orders. On the other hand, when one speaks outside of their official duties, they are speaking as a private citizen, and First Amendment rights kick in. So where do teachers speaking in the classroom fall in this dichotomy? Well, unfortunately, that's not clear. The Supreme Court has not resolved that issue, and lower courts have gone both ways. On one hand, schools do have the authority to set their own curriculum, and the school board can regulate the topics to be covered in the classroom. On the other hand, teachers are not like DMV clerks. They don't simply recite information. They're not required to read from a script, and therefore they have freedom in how they present the material. And that was recognized by the 10th Circuit Court of Appeals here in the Carey case. Quote, "We think teachers do have some rights to freedom of expression in the classroom, teaching high school juniors and seniors. They cannot be made to simply read from a script prepared or approved by the board. The teacher cannot be punished for letting students know other languages are spoken in the world or mentioning the existence of a system of respected human thought." So if we're in a jurisdiction like the 10th Circuit here that recognizes freedom of speech in the classroom, we can move to the next element. And even if we're not in this kind of a court, when a teacher is speaking outside of class, they are likely speaking as a private citizen and not pursuant to official duties. So, on to the second topic, on matter of public concern. This really relates to what is being discussed. You see, the First Amendment is limited to matters of public concern as opposed to speech on personal matters. So what does that mean? Well, a matter of public concern is one that touches upon any matter of political, social, or other concern to the community. So for example, a teacher who reveals official misconduct when criticizing school policies is addressing a matter of public concern. On the other hand, a teacher raising purely personal grievances, like the school's policy on where you can go for break, is not addressing a matter of public concern. And speaking of cases we recently handled, Bonnie, here's a recent example of this issue. We represented a substitute school teacher in southern Georgia whose two kids went to the elementary school where she did most of her substitute teaching. She had been a full-time teacher for 10 years, but then she became a substitute teacher so she could spend more time at home. Her name is Lindsay Barr. At the beginning of the 2022-2023 school year, Lindsay learned that the school librarian was going to start a reading program where she would read a picture book to all kids in the school, one class at a time, from pre-kindergarten all the way to 5th grade. And the first book to be read to the classes was a book called All Are Welcome. Now, Lindsay didn't object to the words in the book, but she was concerned about some of the illustrations, including illustrations of same-sex couples embracing, expecting children, parenting young children, and she was concerned about questions that would be raised about those pictures. So she talked to the principal and expressed her concerns and asked that her kids be excused from the read aloud. The principal agreed to excuse her kids from the read aloud, but then Lindsay was fired from her job. So we sued the school district claiming unconstitutional retaliation, and we recently settled the case on very favorable terms for Lindsay, including getting her full reinstatement and substantial monetary compensation. But before we settled, the court denied our motion for a preliminary injunction, and it did so on this very issue, matter of public concern. The court reasoned that because Lindsay was asking that her own children be excused from the reading program, she was not speaking on a matter of public concern, just private concern. Now, we think the court was wrong because the law does not require a public employee to be devoid of all personal interest in a matter, to be speaking on a matter of public concern. And then in discovery that we took in the case, we developed evidence that showed Lindsay was speaking on behalf of a number of families who agreed with her, not just her own family. So we do think we would have turned the court around, but we ended up settling on favorable terms, as I said. But this story shows you how this element, a matter of public concern, can end up being pretty important. So another question on which the courts are split is whether classroom speech is a matter of public concern. Once again, some courts have held that because teachers are hired to teach certain things, they can't go rogue. For example, by using a class as a platform to present a revisionist view that Benedict Arnold wasn't a traitor. That was actually an example that one court provided. But other courts recognize that teachers are entitled to First Amendment protection in how they discuss the topic, so long as they're covering the curriculum. In any case, the issue will often turn on the facts. Is the teacher going off curriculum, or is the teacher covering the curriculum and being punished for expressing his own views on it? And that could depend on grade level. Courts give the least amount of protection to elementary school teachers because the education is considered compulsory and basic knowledge. High school teachers get more protection because they engage students in more critical thinking. So if the speech is on a matter of public concern, that brings us to the third issue, which compares the interests of the employee in speaking with the interests of the employer who wants to restrict the speech. You see, even when speaking as a citizen on a matter of public concern, a teacher's right is not absolute. A school may restrict a public employee's speech if its interest in doing so outweighs the employee's interest in speaking. That's the balancing test. And a public school will often claim it needs to restrict speech that interferes with or disrupts its operations. The employee's interest, however, gets extra weight in the balance when he or she is discussing sensitive political topics. So let me tell you about two cases to show you how these come out, and they often turn on the facts. The first case involved a teacher in Kentucky who, honestly, I'm not making this up, invited actor Woody Harrelson to speak to her 5th grade class about the benefits of industrial hemp, which at the time was a banned substance in the state. After she did that, she was fired, and she sued, and she claimed that her decision to invite Harrelson to class was protected by the First Amendment. The court held the invitation was speech on a matter of public concern, so proceeded to balance the interests that we just talked about. Because the school had given her permission to invite Harrelson to the class, even though it didn't know the topic, its argument that his visit caused disruption was weak. So the court held that the school could not constitutionally punish the teacher for inviting Harrelson to speak. In another case, a high school math teacher posted banners such as "In God We Trust" and "God Bless America" in his classroom. A different court held that this teacher was not speaking as a private citizen, but pursuant to official duties. So the school was entitled to control his speech, and he was not protected by the First Amendment. So the contrast between these two cases shows that teachers may not use the classroom to indoctrinate students or advance one religion over another, but they do have freedom in the way they express information. So let's turn to teachers' free exercise rights. The Free Exercise Clause protects the ability of those who hold religious beliefs to freely live out their faith, including while they are at work. Now, it is true that a school can establish a policy that burdens religion if it generally applies to everybody and it's actually neutral towards religion. But schools cannot enact policies that target religious beliefs, and they can't act with hostility toward religion. So one good example is last year's Supreme Court case involving Coach Kennedy in Bremerton, Washington. You may recall he was a high school football coach who was fired from his job because he knelt in the middle of the football field after games to give a prayer of thanks. The Supreme Court held that the school violated Coach Kennedy's free exercise rights by firing him because he could have been doing other things during that time. He could have been making dinner reservations. He could have been ordering pizza. He could have been checking his email. So the fact that the school wouldn't allow him to pray was a direct attack on his religion that the Free Exercise Clause does not permit. And in that case, the Supreme Court gave examples of other activity that would be protected by the Free Exercise Clause, such as wearing a headscarf in the classroom or praying quietly over lunch in the school cafeteria. The bottom line is the school cannot adversely target religious beliefs. The final issue, now I'm in trouble. Okay, good. I didn't know if I could go backwards. Okay, so the final issue has to do with the clarity and scope of school policies. Government policies violate the Constitution when they fail to give fair notice of what is acceptable. And that's what happens if the government enacts a policy that's vague or it's too broad. And the reason why that's a problem is it invites arbitrary application, discriminatory discipline, and it chills the exercise of First Amendment freedoms because nobody knows where the line is. Nobody knows what's actually allowed. So numerous attempts to limit what teachers may say in school through broad policies have been held unconstitutionally vague. Here's one example. A policy prohibiting vulgar words was held unconstitutionally vague when it was used to punish a high school English teacher. The word that the teacher used could be found in 5 books in the school library. The court observed that the teacher could not know the word was improper because it was in the school's own books. So the court held the policy unconstitutional. So that's the basic framework on teachers' First Amendment rights. And now I would like to turn to an application of that framework to the area that we're involved in quite often, and that is gender identity theory. So first of all, what is gender identity theory? Well, largely it is a theory that holds these 4 ideas. First, everyone has an important inner state called a gender identity. Second, for some people, their inner gender identity does not align with their biological sex. Those are transgender people. Cisgender people have no misalignment. Third, gender identity, not biological sex, is what makes you a man or a woman, or neither. Fourth, all of society is obliged to recognize and legally protect gender identity, not biological sex. It's important to note that this ideology keeps changing, so these axioms are not fixed. For example, some activists now claim there is no such thing as biological sex, so they would reject the second axiom here. In any event, these ideas have posed challenges for schools on many, many fronts. For example, can a school limit the use of its restrooms and locker rooms to one sex and exclude students of the other sex who claim to be transgender? On that front, a federal appellate court held in December that a Florida school district's policy of sex-segregated bathrooms is perfectly constitutional. You can see the court said, "We disagree with Adams' theory that separation of bathrooms on the basis of biological sex necessarily discriminates against transgender students." But other courts have found the opposite, that separating bathrooms on the basis of sex violates the Constitution. So the courts are split. Then there's the issue of whether girls' sports may be limited to females and exclude boys who identify as girls. On that front too, a federal court in West Virginia in January upheld the West Virginia Sports Act, which limits participation in girls' sports to females. The court said, the fact is that a transgender girl is biologically male and, barring medical intervention, would undergo male puberty like other biological males. Biological males generally outperform females athletically. The state is permitted to legislate sports rules on this basis because sex and the physical characteristics that flow from it are substantially related to athletic performance and fairness in sports. And this is an important decision because 22 states have enacted statutes limiting participation in girls' sports to biological females. But beyond those issues, which are really for the districts, schools are issuing policies supporting gender identity theory and requiring teachers, coaches, and others to affirm students the minute they claim to identify as another gender. And the typical policy contains these terms, and I'm sure many of you are familiar with these. 1, the students can choose any name or pronoun they prefer without parental notification or permission. 2nd, there's no pre-approved list of pronouns. 3rd, students can change their name or pronoun at will, day by day, class by class, etc. 4th, teachers, staff, and students must use the student's preferred name and pronoun. 5th, the school will not inform parents that their child has requested a different name or pronoun unless the student affirmatively consents. And 6th, The teacher must use the legal name and biological pronoun when communicating with parents, but the preferred name and pronoun when referring to the student at school. And the issue of pronouns poses a big challenge for many teachers. And that's because pronouns convey a powerful message. They are seen as a validation of somebody's identity. So when you use a pronoun not consistent with somebody's biological sex, you're sending a message that what makes that person a boy or a girl is not their sex, but their inner feelings. Indeed, using a pronoun is considered part of the intervention being pursued when a child transitions to another gender. So use of a child's name and pronouns is not neutral, but helps cement that child's identity. So imagine a hypothetical teacher who does not want to send a message that gender and sex are different because he disagrees with it and because it violates his religious beliefs. How would such a teacher deal with a school policy that forces him to send that message? Well, there are three potential claims. First, the policy violates the teacher's free speech rights by suppressing his own views and by compelling him to convey a message that he doesn't agree with. Second, the school policy violates the teacher's free exercise rights because of its hostility to the teacher's religious beliefs. And third, the policy is impermissibly vague because there's no limit to what it might require the teacher to do. So now we talked about the framework on these rights before. So let's go back to the public employee speech framework. And let's consider this claim. First, official duties. Now, as we discussed, the Supreme Court has left open whether what teachers say in class are pursuant to official duties. That's not resolved. But most courts would say that in the K through 12 context, classroom speech is pursuant to official duties, which means in those courts, there is no First Amendment claim to protect what a teacher says in the classroom. But our hypothetical teacher should consider whether the policy restricts speech outside of class. For example, when speaking off campus, that would provide a much stronger claim. Furthermore, the requirement to use a student's preferred pronouns is more than a restriction on speech. It is compelled speech. It is requiring the teacher to affirm something he or she doesn't believe. It is forcing the teacher to betray his or her conscience. And the Supreme Court has subjected state action compelling speech to much more scrutiny than action merely restricting speech. So the Supreme Court here said, when speech is compelled, additional damage is done. In that situation, individuals are coerced into betraying their convictions. Forcing free and independent individuals to endorse ideas they find objectionable is always demeaning. And for this reason, one of our landmark free speech cases said that a law commanding involuntary affirmation of objected to beliefs would require even more immediate and urgent grounds than a law demanding silence. So framing the issue this way, as compelled speech, gets around the official duties problem. The First Amendment should provide protection against compelled speech in the classroom, even in those courts that regard what happens in the classroom as part of official duties. And while no court has yet addressed this point, we have briefed it in several cases, and we have one case now pending in the Supreme Court of Virginia on this very issue. And we're expecting a decision really any day. So beyond that, it's well established that issues relating to gender identity are matters of public concern. Indeed, the topic of gender identity is considered by the Supreme Court to be a hotly contested matter of public concern. So that really takes us to balancing. Whose interest is greater, the employees or the employers? Now, the school will argue that it has an interest in not discriminating against transgender students, but there are good responses to that argument. If our hypothetical teacher calls every student by their last name and avoids pronouns altogether, that's not discrimination. And facts matter in these cases, because if you have, for instance, a football coach or other teachers who are permitted to use only the last name, it's harder for the school to claim that another teacher can't take that approach to avoid using pronouns. The school might also argue that it seeks to protect the transgender students' well-being, but that argument is not supported by the evidence. Scientific research is beginning to show that an affirming approach does not help, especially when the student's parents are kept in the dark about a gender transition. So, our hypothetical teacher is also likely to argue that the compelled use of pronouns violates free exercise rights because he or she is being forced to betray their religious convictions. Now, schools will generally argue that transgender policies are generally applicable to everyone and are neutral towards religion, so they don't abridge the free exercise rights. But a school district would violate the free exercise rights if it showed hostility toward religious beliefs. So our hypothetical teacher should ask whether some teachers are permitted to use last names for secular reasons, but teachers who hold religious beliefs are not. That would support a claim. And it's not uncommon for school administrators, when they address and respond to requests for accommodation, to condemn religious views. And those statements of condemnation could also support a free exercise claim. So finally, on vagueness, many transgender policies use poorly defined terms. So our hypothetical teacher might be successful in challenging a policy because it's too vague. For example, these policies often require teachers to use whatever pronouns a student demands, including pronouns such as the ones on the screen now. I won't try to pronounce them all, but you can see they're silly, meaningless, but the fact that a school policy might require a teacher to use those would show that the policy really has no limits, and a court could easily find such a policy to be unconstitutionally vague and too broad. So let me tell you about one case in this area that ADF handled. It's Merriweather versus Hartop, a federal appellate case in 2021. Nicholas Merriweather was a professor at a small public college in Ohio and a devout Christian. And in January 2018, he was using the Socratic method in his political philosophy class, addressing students by their last name with the honorific Mr. or Ms. After class, a male student named Doe claimed he was a woman and demanded to be addressed in class as a woman by the professor with feminine terms. Professor Merriweather reported the conversation to the dean, and they agreed on a compromise. He would refer to Doe simply as Doe, without the honorific. But the student continued to complain. The dean changed her mind and demanded that Professor Merriweather address Doe as a woman, which he refused to do. So ADF took Professor Merriweather's case, and what happened? The court ruled in Merriweather's favor. The school violated his constitutional rights by requiring him to affirm Doe as a woman. Now, this case was in the university context, where courts are more likely to uphold free speech rights, but the case has useful insights. First, the court found that speech on pronouns is a matter of public concern. That's one of those elements we talked about before. Never before have titles and pronouns been scrutinized as closely as they are today for their power to validate or invalidate someone's perceived sex or gender identity. When Merriweather waded into the pronoun debate, he waded into a matter of public concern. The court also found that Merriweather's interests in free speech outweighed the university's interests in restricting it. There are two quotes I have here. The First Amendment interests are especially strong here because Merriweather's speech relates to his core religious and philosophical beliefs. And also, the university's interest in punishing Merriweather's speech is comparatively weak. There is no suggestion that Merriweather's speech inhibited his duties in the classroom, hampered the operation of the school, or denied Doe any educational benefits. And in addition to upholding Merriweather's right to free speech, the court also held the school violated his free exercise rights. That was shown by comments made by his department chair that, quote, religion oppresses students, end quote, and quote, Christians are primarily motivated out of fear, end quote. So Merriweather is a helpful case on the pronoun issue in any context, including K through 12. Another issue we're seeing across the country is the requirement that teachers lie to the parents of a student who is transitioning at school. As we said earlier, schools require teachers often to affirm a student's decision to transition with a different name, pronouns, clothing, even the bathroom the child uses. And at the same time, the school forbids teachers from mentioning any of that to the parents. So a teacher could be in a situation where he or she is forced to refer to a student one way in class and another way with parents, just to keep the parents in the dark about what's happening in school. There is a strong First Amendment case on that, because even with the official duties test, the government cannot force its employees to lie. So now I'd like to tell you about 5 cases in this area that ADF is currently handling. Number 1. Peter Vlaming was a French teacher at West Point High School in Virginia. He had a female student who began to identify as male. He agreed to use the student's preferred name and decided to avoid pronouns altogether for any student. But the school demanded that he use male pronouns when referring to his female student, even when the student was not present. He refused. He was fired. We filed suit in his behalf, and that's the case that's now pending a decision in the Virginia Supreme Court. Number 2, Tanner Cross is a phys ed teacher in Loudoun County, Virginia, and he also serves as a football coach. In May 2021, the Loudoun County School Board was considering a transgender policy, which would allow students to claim any noun or pronoun they believed fit their gender identity. Tanner thought this was a bad idea, so he decided to speak during public comments at a board meeting. He said, "I love all of my students, but I will never lie to them, regardless of the consequences." And he opposed the policy. Because of his speech at the board meeting, the school district placed Tanner on leave and banned him from school grounds. ADF filed suit on Tanner's behalf, and the court ordered his immediate reinstatement. Third, Pamela Ricard. She's a middle school math teacher in Kansas. In the 2020-21 school year, 2 of her female students asked to be addressed by male pronouns. The school's policy required her to address those students by their preferred pronouns, and yet prohibited her from telling the parents about the student's status. Pamela believes addressing students one way at school and a different way when speaking to parents is dishonest and violates her religious beliefs. So ADF filed a suit on her behalf. The federal court found it likely that Pamela would succeed on her free exercise claim and suspended the policy that prevented her from disclosing the student's transgender status to parents. Number 4 on the right side is Travis Allen. He was a middle school girls soccer coach in Vermont. His daughter and other girls on the high school volleyball team were confronted with a male student identifying as a girl in the girls' locker room. The incident became public, and Travis's daughter, Blake, appeared on the news. The mother of the trans student then posted on Facebook that Blake wasn't telling the truth. And so in response to that post, Travis responded on Facebook in a public post, quote, "The truth is your son had a free show watching my daughter undress." The superintendent asked Travis to issue a public apology for those remarks because he misgendered the trans student, but Travis refused. So he was suspended from his coaching position. His daughter was also suspended from school when she referred to the student as a male when she was discussing this issue about the locker room with friends in French class. So ADF filed suit on behalf of both Travis and his daughter Blake. The day we filed suit, the school revoked the discipline it imposed on Blake, and recently we settled the rest of the case, getting Travis reinstated to his coaching position and obtaining substantial monetary compensation for the family. Finally, Rachel Sager and Katie Medart are 2 educators in Grants Pass, Oregon. They developed iResolve, a grassroots program intended to protect the hearts and minds of youth and to stand up for truth in society. The resolutions propose that schools designate shared bathrooms and locker rooms as anatomically male or anatomically female, and that students who were uncomfortable could request a private bathroom or locker room. The resolutions also propose that students, with parental permission, could ask to be called by a derivative of their legal name or preferred pronouns, but that teachers and peer students would not be mandated to obey those requests. In spring 2021, while they were not working, they created a website and a video for this program. And after the website and the video went public, a few district employees complained. They were appalled, offended, and disgusted by Rachel's and Katie's views. The superintendent sent out an all-staff email declaring that iResolve was in direct conflict with the values of the school district, and Rachel and Katie were terminated. So they filed a lawsuit. The trial court ruled against them, holding that the school district's interest in protecting the safety and well-being of the students, again, this balancing test we talked about, outweighed the plaintiff's right to comment on matters of public concern. We believe the decision is extreme. The court basically determined that merely advocating for common sense solutions on issues of gender identity caused jeopardy to the students. So we did not represent Rachel and Katie in the trial court, but ADF is now representing them in their appeal. So these are just a few of the cases we're handling. As I said earlier, we're getting calls every day. And so if any of you feels like you have been punished or canceled because of saying something you believe as a public teacher, or because you follow your religious beliefs, then you should certainly give us a call and we'd be happy to talk to you about that.